Welcome to LawWiser. As we all are aware and we are bracing through the second wave of pandemic, there is growing need and demand for vaccination. There are a lot of issues with respect to this vaccination that everyone's facing. Many are advocating compulsory licensing for it. In this video of ours, we will be discussing all the issues that revolve around the COVID vaccine and compulsory licensing. To discuss this, we have expert with us today. We have Ms. Rajeshwari Hariharan. She's the managing partner at Rajeshwari and Associates. They're experts in trademarks and patents. Welcome, ma'am. Thank you for taking time out for us.
Yeah, thank you so much for inviting me on your show here.
Thank you. So, to start our conversation, one of the basic questions that we have is if you can explain this whole issue of producing and accessibility of vaccine from the IP perspective.
I will do so. So, there are two different things that we're talking about here. One is the drugs which are required for treatment of COVID, and then we have a whole bunch of vaccines which are important so that the entire country is vaccinated. Now, some of the drugs which are important for treatment of COVID are patented by many companies. Some of the vaccines, not all of them, but some of the vaccines are also patented. So because there is a patent cover for all of these vaccines as well as the drugs, other Indian companies are unable to come and start manufacturing it quite like a Crocin or any other such drug. Whereas if there was no patent and if it was free, then perhaps a number of companies would have come. Now, the patent holders are people like Gilead, or you have, the Japanese companies. So the Indian companies are required to either take a license from those companies and then manufacture, or, if they manufacture at risk, then perhaps they will face litigation. So that is the whole paradigm here, and that is the one that limits the access to medicines and to vaccines. And the demand of the entire society and everyone around here is that wherever there are drugs and vaccines which are patented, then all of those should be made free of the patents. The patents should be waived, or they should be suspended for a certain period, so that manufacturing base can be expanded. More and more companies can come in and they can start manufacturing, and then it can be made available on a large scale. Now we have remdesivir. Now this is patented by Gilead. So only a few companies can make it. That is only the licensee. But if there were other companies who were able to make it, so suppose another 20 or 30 companies could make it, perhaps you will have a lot of remdesivir, not only to use for India, but you'll be able to export it as well.
Thank you for explaining this issue, because a lot of people would have been confused that why is it so difficult to actually, manufacture or produce the vaccines that are required in these times. Moving further, if you can explain to our audience what is compulsory licensing and in what circumstances can it be issued?
So, compulsory licensing is another provision which has been incorporated in our law. It's been there from the very beginning. But when India signed the TRIPS, and then we made some changes in our Patent Act in order to conform to TRIPS, then we amended our law and strengthened those provisions. So, compulsory license has got three forms, where the government by itself, thinking that there is a natural calamity, or there is a public urgency, there is an extreme urgency, there is a necessity, national emergency. The government can by itself say that, well, we think that there is a national emergency and therefore we want to suspend the patent for a certain period, and we want to authorize other companies to manufacture the drugs. That's one form. The other is that the government will issue a notification in the Gazette and then invite several companies to bid for compulsory license, and then issue an actual compulsory license to them and pay a certain royalty to the patentee. Then there is a third kind of compulsory license, which is where the companies by themselves will approach the inventor or the innovator who is holding the patent and then voluntarily ask him, please give me a license. In the event he does not grant such a license voluntarily through negotiation, that person can approach the controller and say, look here, he is not giving me any license. So can you please, grant a compulsory license to me? Then the controller will consider the circumstances and then will issue the compulsory license. The third one, which I talked about, is the long procedure. The second one also involves the issuance of a notification. But the first one, which is available under Section 100 as well as under Section 47, is a far easier route where the government by itself is empowered to use the invention for itself. Either it might give a contract manufacturing or it may import the drug. It can use the patented medicine in any manner. That includes the vaccines, that includes the drugs, it includes every form of the COVID products which we are now using. That includes even testing kits. So whether an application is pending or it is granted, the government has the right to step in and to start using those patents. It may be for a certain period, it may be for a longer period, it is up to the government entirely. So these are all flexibilities which have been incorporated into our Patent Act, keeping in view the TRIPS compliance.
Thank you for explaining, how compulsory license actually works out in our act. Moving further, why the agreements such as TRIPS have not really been used to waive the IP rights, especially in the current prevailing scenario?
I think what is you must understand as to how TRIPS works. TRIPS is a agreement which is signed by some 164 countries. So all of those countries have to come to an agreement on a certain issue for some declaration to be made by TRIPS Council. So we have something called a TRIPS Council. So the TRIPS Council is the one who will issue a declaration from time to time. If you may recall, once in 2001, the TRIPS had issued a notification, a kind of a declaration in Doha, which is very famously called as the Doha Declaration, where they have said that, well, if there is a public urgency, if there is a public health crisis, the governments have the right to issue compulsory license. This is something which was already there in the TRIPS. It was just a reaffirmation of something which was already there. Now, India and South Africa are saying that IP rights, whether it is patents or trademarks or copyrights or data or any other kind of rights, whichever exist on COVID drugs as well as vaccines, they should be suspended for the period of the pandemic. This is the demand. Now, so far, US and various other countries have been opposing it. Of late, on the 5th of May, US administration announced that they will be supporting it. Now, for TRIPS Council to meet, to discuss, to get the consensus of all the 164 countries, get them on board, get them to sign it, is going to be a long process of negotiation. It is not something that is done overnight. There are many countries like the EU, Germany, etc., who are saying that, look here, if you issue compulsory license or you suspend IP rights, then it will undermine our intellectual property rights. It will undermine our efforts to create vaccines, and therefore they are opposing it very stiffly and sternly. So, although those arguments may be without any merit, but then there are those arguments. So, therefore, the TRIPS Council will have to deal with all these issues, and then a declaration will have to be made. So, therefore, that is going to take a lot of time. So, while we have, if you're looking for actual TRIPS declaration, that's going to take time, but there are flexibilities which are available within our law, which we can use immediately, like I said, Section 100 or Section 47. Those can be used by the government immediately, and we can make many companies to manufacture the product, and the vaccines and the drugs can be made available quite quickly.
Thank you for actually explaining how the TRIPS agreement actually works, and why it will actually become a long process to get things done. So moving further and lastly to our question, um, can the competition law in India be availed to issue compulsory licensing? Would it be a viable option in the present scenario?
So, competition law is a very good question. Competition law definitely has a provision to curb the abuse of dominance. Competition law is always meant to ensure that the public has full access to the market. What does that mean? That there should be enough competitors in the market so that products are available on a large scale and products are available in such a manner that the price gets regulated. So it's quite like saying if there are five people manufacturing a matchstick, obviously the price is going to be down. But if there is only one person manufacturing the product, the price will be high. He will command whatever price he wants. So when he has the IP rights and if he is the only person manufacturing the product, then there is bound to be an abuse of dominance. It's no harm in having the IP rights. So merely having the IP rights is not abuse of dominance. But if the IP rights are exercised in a manner that keeps competition away, that regulates the market in such a manner that everyone else is kept out of the market, and there is a public health crisis, then the competition commission can make a reference to the controller of patents and tell the controller of patents that look here, we feel that there is an antitrust issue here. We feel that there is an abuse of dominance issue here. So why don't you consider granting compulsory license? So again, this is a process that someone has to make a complaint to the competition commission. The competition commission has to hear the matter. They will have to conduct an inquiry. Once they come to a conclusion that yes, there is an abuse of dominance, they will refer it to the controller of patents. Then the controller of patents has to consider it and then issue a compulsory license, which again will take some time. Yes, it is something which is technically feasible in law, but practically it will not yield much results in the current pandemic because we need the drugs, we need the vaccines, we need the kits here and now. We can't wait for years.
Thank you so much. Thank you, Rajeshwari, for taking time out for this and in such a short time explaining to our audience the entire issue of compulsory licensing, how the TRIPS agreement work and whether competition law is actually a viable option or not. Because today there is an urgency of vaccination and we all know we are facing with the shortage. We hope things get sorted and everyone is able to get access to the vaccine as soon as possible. Thank you, Rajeshwari. Thank you.
Thank you so much for inviting me. Thank you very much.
Thank you.